Hi, everybody. It's Wednesday night. Welcome to True Crime Wednesday. I'm Lori Hellis. I am a retired criminal defense attorney, criminal attorney in general, and I've written a book about the Lori Vallow case. And every Wednesday night, we get together and talk all things true crime. I want to say hi to Julie tonight, my friend Julie. Julie and I got to know one another when I was living in Boise. And for my Boise friends, for Cheryl and Julie in particular, I'm going to be in Boise for a book signing on March 25th at Rediscovered Books. So if you all, anybody out there happens to be in the Boise area, I'm going to be in downtown Boise. I am also going to be at the Tucson Festival of Books. And that I am going to put these details in our show notes, but I'm going to be at the Tucson Festival of Books on the 15th and 16th of March. And I will be in Phoenix for a book signing on the 17th of March. I don't have a time on that yet. So some of those details still TBD. But that is being done in cooperation with my brain just blanked out, but with the bookstore in Phoenix and the Phoenix Library. And I think it is called New Owner Books, but I will double check. And we'll put that all in the show notes. So if you happen to be in the Phoenix or Tucson area in mid-March, I hope you'll come out and see me. So we have a few things to talk about tonight. And first of all, I want to say thanks to everybody who answered my plea for feedback and who gave me some really helpful ideas. And I'll get into that a little bit later once people are joining, so we can talk a little bit more about it. But I really appreciate everybody's really kind words and great responses. So first of all, let me tell you what is going on in my world. That is what is going on in my world. And as you can see, if you look down below, the low temperature today, which was just before sunup, was 0. Now, I know there are a lot of people out there for whom this is just average winter. I did spend a winter when I was in the military in Champaign-Urbana, and just outside there. And it wasn't at all unusual to see 30 below temperatures. So I know, but these kind of temperatures are pretty unusual for us. So we'll be dealing with that. We've got snow coming in tomorrow and part of Friday. So I'm going to run out and my traitorous children are in Hawaii, and they're coming back on Friday night. And my traitorous husband is on his way to the Phoenix, suburban Phoenix area for the spring baseball conference for Oregon State University, and with a bunch of his guy friends. So I'm going to be here all alone in the snow and the cold. But I am going to get out of here next month and go to Tucson for a week. And I'm looking forward to that. Those of you who know me know I really love Arizona, loved living there. So I'm looking forward to that. So let's chat about a couple of cases that I want to give you updates on. And then we'll do a little bit of a deeper dive into a couple of other cases that are heating up. So in particular, we're going to talk at length about Karen Reed and some of the motions that have been filed by both sides in that case as we run up to the April 1st trial date. But I did want to talk a little bit about a couple of cases. First of all, I want to talk about Naomi Payton and Kelsey Payton, who are the victims in the case. And this is a case that was brought to our attention last week by Rachel Gamber. So thank you, Rachel, for bringing that to my attention. I asked Rachel to email me with some details so that I could look a little bit deeper. Rachel's question had to do with the fact, and I'm going to talk a little bit about the details of the case, so it makes a little more sense. But Rachel asked me about why the surviving child in this case wasn't being placed with her dad. So I did a little bit of research. This is it's a really sad case. So Kelsey Payton was married to Eric. His last name is different. She was his first husband. He was her first husband, and he was Naomi's father. He was the father of the two children the two children. I don't have the mother's name written down because she's not really a player in this. The two girls were removed from her care and were placed with their aunt, Kelsey Payton, in what is called a kinship placement. So what happened was mom was apparently not taking appropriate care of the children, and for whatever reason, they were not placed with dad. Now, that could be a number of reasons. It could be that they couldn't locate dad. It could be that legal paternity had not been established. So there's a number of reasons that could have absolutely nothing to do with dad's fitness as a father, but could just have to do with the legalities of the case. Nonetheless, the two girls were placed instead with their aunt, Kelsey, and her husband, whose name is Wendell. Now, these folks are of Native American descent, and the Indian Child Welfare Act applies when child welfare is involved. So we'll talk a little bit more about that. But apparently what happened was that for some reason, the children were not placed with the biological father. They were placed with the aunt, the mother's sister. So the mother's sister was married to Wendell Payton. Wendell Payton? Is that right? Yeah, I think that's right. And the two little girls. Oh, thank you, Rachel. That may be. I didn't get that far into it, but it appears that Naomi's mother had died, and that's why she was placed with her aunt. Now, it's not clear from the news reports why the children were not placed with their dad, but there are a lot of legal reasons that might happen. One being that he didn't have legal paternity established. The other might be that they couldn't locate him when they made the placement. Now, the Indian Child Welfare Act applies when a Native child is, or a child who potentially could be enrolled in a Native American tribe comes into state care. So becomes a ward of the state. The first thing that the Child Protective Services has to do is they have to do a familial survey. So they have to figure out who's related to this child. They have to figure out whether or not the child is eligible to be enrolled, because every tribe has slightly different criteria for how children, Native children, get enrolled. And some of it has to do with how much Native American blood the children actually have. We don't know any of that. But we do know that child welfare, in any case where it is indicated that there's some sort of hint that there is Native American familial connections, the child welfare organization is required to identify and to discover whether or not these children are eligible to be enrolled, if they're not already, and whether or not there are Native American family connections where they could be placed. Now, it's not clear from the news reports whether the aunt and uncle were actually tribal members or enrolled or eligible to be enrolled themselves. They clearly, by the pictures, are people of color, but it doesn't. It's not very clear what their heritage is. So we don't know, but we do know that it is typical in all child welfare cases, whether they are Native children or not, for child welfare to be required to find a family placement before placing the children in a stranger foster care. So the first thing they have to do is they have to inquire from family members whether there is a family member who can provide care for the children as a foster resource. That's called a kinship placement. Doesn't have anything to do with the Indian Child Welfare Act. It just has to do with the fact that in every case, child welfare is required to identify family resources first, because clearly that's what's going to be in the children's best interest if they to be placed with family members they know rather than with strangers. This is what happens when I try and fuss with my hair. It ends up sticking to my face. So that's what happened. The children were placed with this aunt and her husband. And unfortunately, it was a case where there was indications of domestic violence, and there were indications that there was unrest among the family. Uncle Wendell apparently set the house on fire. It's unclear from the news reports whether his wife and the youngest of the two girls were alive when he set the house on fire or not. Nonetheless, they were found deceased in the basement. The uncle also was in the house and came out of the house. The 6-year-old girl managed to get outside the house, and firefighters found her outside the house. They were unable to save the aunt and the younger girl. And apparently what has now happened is that the biological father is attempting to get custody of the 6-year-old girl who's still alive. The uncle has been charged with both murder and arson for the deaths of both his wife and 3-year-old Naomi. So it's a really awful case, and I'm certain that we're going to hear more about it. Rachel, I'd love for you to keep us up to date on it as you hear more. It doesn't appear to me at this point that the Indian Child Welfare Act is controlling the placement of this child, because ICWA would not preclude the child being placed with their biological parent, even if that biological parent is not Native, which it appears, at least from the photographs, that Eric, the biological father, is not Native American. Now, there are a lot of Native American people who have Native American heritage and are blonde and blue-eyed and do not appear to have Native heritage. But it doesn't appear at first glance that he is involved with the tribe. So what that means is, regardless of his status as a Native American, he still has priority to be the placement for his child and to have custody of his child. I expect over the next little while that child welfare will place the child with him if they haven't already. As long as he is able and fit, usually it takes a fairly brief examination to make sure Child Welfare Act is the Child Welfare Organization is going to do a background check on him, criminal history, make sure that he doesn't have any history that would make placing a child with him unsafe. No abuse or neglect allegations, no abuse or neglect arrests, those sorts of things. Once they have cleared him and are convinced that he's a safe placement, I suspect she'll be placed with him. She is clearly a child that is going to need a lot of attention and a lot of therapy and a lot of time and space to recover. She's had a lot of trauma. So thank you, Rachel, for bringing that to our attention, and please keep us up to date as the case goes along. I had a couple of other questions. One was about rapid DNA in Arizona, and I have not done the research on that yet, but I will answer that question. The other was about Lindsay Shiver, and I will update everybody about Lindsay's case as well. But I do want to move on to the case that a lot of folks have been watching for the last couple of weeks, and that is the Megan Boswell case. Megan Boswell has been on trial for the death of her one-year-old daughter, Evelyn. Closing arguments happened today, and I have to say that the closing arguments I thought were a pretty good summation of the evidence. So if you haven't been following the case and you want to catch the closing arguments, that's probably the best place to get a quick summation of the facts of the case. Essentially, the state is arguing that Megan Boswell met a new boyfriend. The new boyfriend wasn't really interested in having her one-year-old Evelyn around, and that she may have murdered the child so that she could have a fresh start with a new boyfriend. That is the state's allegation. For some period of time, she allowed another guy who she went to high school with and had known for a long time to believe that he was Evelyn's father. It turned out that he was not her biological father. But for some period of time, she told everyone that he was her father and that he had custody of her. It wasn't true. He never had her in his care. He's in the Army and actually was living in the barracks and was not in any way equipped to have a young baby with him. So he had met her, seen her on occasions when he was home from the Army on leave and visiting, usually around the holidays. But he had not ever parented Evelyn. So it's a really heartbreaking case. And it's interesting from there were a couple of exchanges that were worth listening to. One was with the medical examiner. There were two different medical examiners. One was the actual medical examiner who did the autopsy. The other was a doctor who reviewed the medical examiner's reports. That woman, who is a very experienced forensic pathologist, had a few things to say, and she had a little bit of a fiery exchange with the defense attorney over whether or not she was going to answer his question yes or no. So if you get a chance, that's worth watching. Otherwise, I think it was kind of a generally sad case. She came from the defendant, Megan, came from a pretty shattered family. Her dad appears to have tried to help her and keep her sort of on the straight and narrow, but it wasn't simple. And at different points, she blamed several other people, including her own mother. At one point, she said her mother had the baby, and her mother told her she wasn't a fit mother and gave the baby to someone else because she said the baby would be better taken care of. And there was a lengthy search for this baby before her body turned up in Megan's childhood playhouse in a garbage can. So very sad case. And that really is, there are a couple of other trials going on, which I haven't followed. Although if anybody wants me to look into them, I will. None of them seemed, I don't know, none of them seemed, I don't want to say not interesting, but the details and the legal issues didn't seem all that compelling. So if there is one of those recent trials that you would like for me to take a look at, I will. I did note that Madeline Soto, who that's a case out of Florida, and her abuser and mom's former boyfriend, Stephen Stearns, is in custody for her murder and some very extensive abuse as well. I did notice that a couple of people from her school were arrested, and the internet seems to be making a really big deal out of that, but it's completely unrelated to Madeline and what was going on with her. So one of them was a choir director. It's possible she may have had this person as a teacher, but there's no indication that any of those arrests are in any way related to Madeline. And, you know, I think it's interesting that there are a couple of creators that have sort of used it a little bit as clickbait. So, but we're in a bit of a lull right now on some of these really high visibility cases. And a lot of that has to do with the fact that we're just coming out of the holidays. And the holiday season slows things down. It just does. So we're going to see things pick up. There are a couple of things coming up in March and April that are going to be, March and April are going to be popping. Of course, we have Lori Vallow coming up, her first trial, which I believe is, you know, this judge originally said he was going to schedule the oldest case first. And I read that to be the one that had been indicted first, because although Brandon Boudreaux, the attempt on Brandon Boudreaux's life came chronologically in October, and Charles died in June of 2019. 2019, that's right. You'd think I'd know that. But actually, Brandon Boudreaux's indictment came first. They didn't indict on Charles's murder until later. So I sort of took it as probably most lawyers would, that the oldest case would mean the one that was indicted first, and that's Brandon's. But in fact, the judge was talking about the oldest case calendar-wise, meaning the one that happened first. So the trial for Charles Vallow's, the conspiracy to commit Charles Vallow's murder, will start on the 31st of March. The final pretrial is on the 18th of March. So, and I'm going to be down there. So we'll see whether or not I can get to Maricopa County and actually sit in on that one. I might try. So that is coming up in March. And let me see here. April 1st, we have the Karen Reed trial. On the 16th of April, we have another hearing on Tiffany Adams. Tiffany Adams is the woman who had her grandchildren's mother murdered, along with a woman who was there to help supervise the exchange. And then on the 28th of April, we have Corey Richards, if that one goes. So we do have some interesting things coming up. One other thing that we have coming up is a preliminary hearing on James Craig. James Craig is the Colorado dentist who is accused of having poisoned his wife. He also is the guy who has been charged with new charges having to do with him trying to solicit someone in the jail to murder a detective, and also been charged with witness tampering for attempting to get false trying to get somebody to testify falsely. And that one had to do with him trying to get people to testify falsely that his wife was suicidal, because he keeps saying that her death was self-inflicted. So he comes up for a preliminary hearing on February 14th. Happy Valentine's Day, Mr. Craig. And I don't know yet whether that's going to be live streamed, but I hope so, because I'd like to follow along on that case. So the next case I want to talk about is Lindsay Clancy. Lindsay Clancy is the woman who is accused of having strangled her 3 children before jumping out a window in an attempt to harm herself. She is the woman who is now paralyzed because of the injuries she incurred in that jump from a window. And she is scheduled to go to trial in January of 2026. But as you might suspect, there are a lot of dueling motions, conflicting motions going on. So I wanted to talk a little bit about that case. And what the heck here? My goodness. My StreamYard is acting up, so let me just get you all back up where I can see you. Hopefully you can see me, because I've got this funny pop-up all of a sudden that started interfering with StreamYard. So hopefully you can all still see me. So the one thing I wanted to talk about with Lindsay Clancy is The defense claims, and she had just recently, the youngest child was still very young, and the defense claims that she suffered from postpartum, not just postpartum depression, but postpartum psychosis. And this is a condition which is rare, but not unheard of. And sorry, I'm reaching across my desk for something. It's not an unheard of condition. And we heard about it with Andrea Yates, who you will remember was initially found guilty, and then her conviction was overturned by the Supreme Court, who found that, in fact, she suffered from a mental disease or defect that made her not guilty by reason of insanity. Now, that again varies from state to state. In some states, we have guilty but insane, and then there is a nuance to. And then in some cases, we have not guilty by reason of insanity. So what I wanted to point out is that there is some pretty compelling information that she was suffering from postpartum psychosis, and also was suffering from mental illness and over medication, is what her defense and her husband also claim. On the flip side, the prosecution says, no, she wasn't mentally incapacitated because she was able to send her husband out to pick up food, take out food, and also, I think, a prescription in order to get him out of the way while she did this horrible deed. And I think, as we saw with the Lori Vallow case, it could be both. Because she had delusions doesn't necessarily mean that she was unable to reason enough to reason that her husband would stop her from doing something horrible and to get him out of the way. I mean, I don't think it's unreasonable to think that's a possibility. But the prosecution is saying, no, that means that she was not mentally ill and knew right from wrong and knew the consequences of her actions. It is a very thorny legal issue. The issue of whether or not someone is insane at the time that they commit the crime. And that is going to have to be a decision that is going to have to be presented to a jury through probably numerous experts who will testify about the impact of postpartum psychosis, and experts who will testify specifically about how it impacted Lindsay Clancy. So that one remains to be seen, and she is not expected to go to trial until January of 2026. So the other Lindsay that y'all wanted an update on is Lindsay Shiver. And Lindsay Shiver is a more, I don't know, I find this case a little bit amusing, maybe. Lindsay Shiver is a woman, and maybe the reason is because nobody got hurt. It's easier to laugh at this one because they were caught before anyone got hurt. So Lindsay Shiver was a college cheerleader, beauty queen, married the big man on campus, who was also very, very wealthy, and who was living the good life in a multi-million-dollar home and flying on a private jet to their vacation property in the Bahamas, when she decided to have an affair with a younger man who was a bartender at the local watering hole in the Bahamas where their vacation home was. And when her husband found out, he promptly filed for divorce and for custody of their 3 young children. And one afternoon, she went out to the car to get in the car with he and the children who were going off to the Bahamas for the weekend. And he said, you're not going with me. You're not getting on the private plane. You're not going. And the police had to be called. And so finally the police said, we're going to separate you two. You need to go. And so then she decided to take a commercial flight to the Bahamas. So she was in the Bahamas, and what happened was earlier in that week, before the confrontation about flying on the private jet, earlier that week, there had been a break-in and a burglary in the restaurant and bar where the boyfriend worked. And the next thing that happened was police, in investigating that, felt that it was an inside job. And so they asked to see everyone's phones. Now, Bahamian law is different than US law. Bahamian law is, because the Bahamas were originally a British colony, it is based on British common law and not on US law. So there are differences and nuanced differences because they don't have to comply with the US Constitution. So I don't really know what the rules were, but they asked to see all of their phones and they reviewed the employees' phones. And in going through this guy's phone, they found text messages between he and Lindsay and a third guy about killing Lindsay's soon-to-be ex-husband. And the Bahamian police took it seriously, and they detained Lindsay and the other 2 men and charged them with conspiracy to commit murder. So the next thing that happened was that they were all arrested and they were all held in the Fox Hill prison. Now, the country of the Bahamas only has 1 prison. So everybody from all of the out islands and from everywhere goes to Fox Hill, and that is in Nassau. And then Nassau is the headquarters for the National Police as well. And Fox Hill is known to be one of the 10 worst prisons in the world. The conditions are abysmal. Now, I understand my husband's only sister has lived most of her adult life in the Bahamas, was married to a Bahamian man and a Bahamian doctor. And so I know a bit about their system, and I know a bit about, and I know a few people that live there and a few lawyers. And so as I understand it, the women's facility at Fox Hill is slightly better. They at least have toilets and live in kind of a dormitory setting. But the men, actually, the cells are pretty much open to the air. I mean, the cells, there's no windows. It's all just bars, and they're vermin infested, rats, insects, and there isn't any running water, and there aren't any toilets. They use a bucket. I mean, and if you want your loved one to actually have edible food, you can deliver it. There's a tremendous amount of bribery and corruption within the system. And, you know, the only way that your loved one gets decent treatment is if you're paying off the guards. So it's a horrendous system. So Lindsay Shiver was held for a couple of weeks there, and then she was released on an ankle monitor, and she was told that she couldn't leave the Bahamas. Later, she petitioned the court for permission to go back to the US, continuing on the ankle monitor, and to live with her parents. She initially asked to do that around the holidays, so that she would be able to perhaps see her children over the holidays. And that was allowed. That was a year ago. And so she's been out on ankle monitor and bond and in the US for the last year. Well, once again, the Bahamian system is much different than the US, and they are very, very sensitive to pretrial publicity. Now, some of that may be the fact that they're a very small country, and it's very easy to pollute the jury pool and not to be able, and so that they aren't able to seat a not unbiased jury. So they're very strict about it. And the judge in this case issued a gag order saying that they were not allowed to, no one involved in the case was allowed to discuss the case with the press. Well, Lindsay Shiver entered into an agreement with one of the news, I don't know if it was Dateline or 2020, one of the news organizations that does a lot of true crime reporting. And she had a film crew following her. So shortly before Christmas this year, she was required to be in the Bahamas for a hearing. It was a scheduling status sort of hearing. And when she arrived at the courthouse, she had this film crew in tow. She told the judge that she believed that the film crew was not going to be publishing anything until after her trial, that they were filming, but that nothing would hit the airways until after the trial. Well, that wasn't true. It wasn't true according to the judge asked to see their contracts. Her contract with the company. And it wasn't true according to the contract. And they had actually aired some footage in the US. Bahamas get a lot of US channels. And so the judge revoked her release and put her back into Fox Hill, where she has been cooling her heels for several months. She appealed her bond revocation after the gag order violation. She appealed to the Supreme Court and lost. So she is still in a Bahamian jail, and we don't know when her trial will be. I don't believe that it will be broadcast because of the judicial gag order. That could change. I mean, once a case is set for trial and a jury is seated, sometimes it doesn't matter, but I suspect that it will not be broadcast. And there's no telling when that trial will actually happen. I suspect that their system is pretty overloaded in terms of trying to schedule things. So it wouldn't surprise me if Lindsay Shiver doesn't have a trial date anytime soon. So, I wanted to talk a little bit about Tiffany Adams. These are the 5 people who were involved in the murder of Veronica Butler and Jillian Kelly. Veronica Butler was Tiffany Adams' the mother of Tiffany Adams' grandchildren. She was Tiffany Adams' son was the father of the children. They weren't married. Veronica Butler, the children had been placed with Tiffany Adams, and it's unclear at this point whether that was the state was involved and placed the children with their grandmother, or whether it was some sort of voluntary placement to avoid that. It's a little bit difficult to tell. But Veronica Butler did believe that she was on the verge of getting the custody of the children back, and for sure was going to begin having unsupervised time with the children. Now, Tiffany Adams alleges that there was abuse going on from Veronica Butler's family, that Veronica Butler failed to protect her children from. There's no indication that that's true, but that is what she claimed. And she enlisted her boyfriend, another couple, and another friend, so 3 men and 2 women, in a plot to murder Veronica. And she called Jillian Kelly, who was there she was the pastor's wife at the church where Veronica attended, and had volunteered to go along as a supervisor to supervise the exchange of the children and to supervise Veronica's parenting time. They met between their homes, which was a couple of hours away for both of them, in this incredibly remote, like 2 roads crossing in Oklahoma. And Veronica's family got concerned when she didn't come back, because they were planning a birthday party for one of the children. Veronica and Jillian's bodies were later found on a piece of property that one of the men had access to. It didn't belong to them, but he had access to it. So they all had preliminary hearings. Some of them waived their preliminary hearing and agreed to come and testify against those who had not waived their preliminary hearings. So Tiffany Adams' next court appearance is on April 16th. And I think at that point, we're going to expect that they're at least going to set a trial date. You know, those could move several times before everything is done. But I think that's at least the indications are that at the next hearing, they'll set a preliminary trial date. So, and there was a little excitement for Donna Adelson, the other bad granny. She is complaining that she's not safe in jail, and that her lawyers have filed a motion for her to be allowed out on bond because she's not safe in jail. So there are a couple of incidents that she is claiming. One is that someone ran their hand down her back while she was in the shower and asked her if she liked it. And the other one was that she needed a Band-Aid for her finger and didn't get it. And one other incident where she was physically accosted and may have had some bruises. So what we don't know is whether or not Donna Adelson had anything to do with inciting any of those events. So we don't know whether the alleged assault had to do with Donna running her mouth or not. But I gotta say, that's jail. You know, jail, it may not necessarily be the greatest place in the world to be. It's not fun, and people get out of line, and that's jail. You put a bunch of people who are not necessarily known for following rules together in one place, living in less than ideal circumstances, and you're going to have those things happen. So, do I think Donna is going to be, poor little old Granny Donna is going to be allowed out until her trial? Nope, I don't. And the judge in the case seems quite intent on keeping the trial date on, which is set for June. So we'll get more updates on that as time goes along, but I do not believe that Donna is going to get out of jail. I do think, and it's interesting, I saw I'm looking at my phone here. I saw a thumbnail from Peter Traeger who says the attorney conflict is worse than we thought. I don't really know what that means because I thought it was pretty bad to begin with, but I didn't get a chance to listen to it before we started, so I'll tune into that. But Peter's done a really good job of covering that, as has Joel Waldman from Surviving the Survivor. Both of them are in Florida, and so it makes sense that they're able to cover the case more extensively. Joel actually has a couple of lawyers who have become friends who are from the Tallahassee area and are on with him quite frequently. And so they kind of get the inside scoop. A couple of days ago, Joel was on with the other lawyer whose name escapes me right now. And he'd actually been in the courtroom when Donna Adelson's last hearing happened because he just happened to be there because he had other cases on. So it's handy when you're in the area and you have the ability to be there in person. And speaking of that, Gigi from Pretty Lies and Alibis has been in a trial, which is happening in her hometown, and it is the Christina Purcel trial. It is being broadcast, and they're calling it the Rose Petal Murders because her body was found scattered with rose petals. It's kind of a factually sort of a convoluted case. It involves Christina, who was married and had a child, and her former husband obtained custody of the child and took her to Italy. He alleged that he was getting her out of an abusive situation, a situation where mom and her boyfriend of fiance, kind of on and off fiance, were responsible for abuse. The fiance is currently in custody, awaiting trial on those allegations. So there appears to be some basis for those allegations. I mean, in child custody cases, we frequently see both parents hurling those kind of accusations as a way to get a foot up in the custody battle. And that doesn't appear to be what's going on here. There appears that there were actually some prosecutable criminal acts that involved the child. So the father who went to Italy and took the child had a friend who, and it's really interesting if you take a look at these people, both the father of the child and the fiance are considerably older than Christina. I would say a good 20 to 30 years older. than Christina. And but the ex-husband's friend was younger, redhead, and was very invested in protecting his friend and this child. And so, although the ex-husband was in Italy at the time, his friend, younger friend, is accused of having committed the murder. It's just a really convoluted set of facts. So Gigi from Pretty Lies and Alibis is covering it because she's in the courtroom every day because it's there in her hometown. So she is probably the best source of information, but it is also being covered on Court TV, I think. So either way, I think we'll keep an eye on that one. I'm going to be following it, and we'll have some updates for you probably next week. And then finally, I wanted to talk about Karen Reed. Now, as we've been talking about, there are a lot of creators out there who are definitely covering things sort of wall to wall. So if you want to know about, really get in the weeds on a lot of these motions, Melanie Little was literally going through them line by line earlier today. That's not something I do because those things are out there for everybody. But I do want to talk a little bit about some of the motions that are out there. And I also, before we do that, I'm going to share my screen because I did have a couple of comments that I wanted to share with you. So I had a couple of kind of interesting comments that I wanted to share. I don't know if you can read these or not, but I'm going to read them to you. The first two were lovely comments from very nice folks. And the last one, I took the liberty of redacting the name, but I thought it was kind of interesting. The comment was, cannot believe you are drinking the Karen Reed Kool-Aid. Got plenty to say about the law trying to prosecute her with a plethora of evidence, but you got nothing to say about the violence and disturbing behavior of FKRs, that is Free Karen Reed. Didn't pick you for woke. No wonder your channel isn't growing. Wow. So I wanted to just say a little something about that. First of all, what I wanted to say is I make no bones about the fact that I am a criminal lawyer, that I am wed to the Constitution, that I believe in it. I believe that it is sacred, and that I am going to always point out when I think the Constitution is not being followed or being violated. That if that makes me woke, then scroll and roll, my friend. If that makes me woke, okie doke. Yeah. So here's what I have said all along. I watched every day of that trial, every minute of that trial. And in the end, I agreed that the state did not prove their case. They did not prove that Karen Reed backed over John O'Keefe at 26 miles an hour. They did not prove their case. And there was a tremendous amount of reasonable doubt, which is why the jury found her, for all intents and purposes, the jury found that she was not guilty on 2 of the 3 charges and hung on 1. Unfortunately, the judge didn't inquire to the jury about any of that information. The jury didn't really know that they could find not guilty on individual charges and only hang on one count. And as a result, the judge declared a mistrial without ever inquiring of the jury. And Karen Read is going to be retried on the 1st of April. Now, there is a circus going on outside of the case itself. And it all started out with a guy named Aidan Kearney, I think is the way he pronounces it. Carney, actually. And he goes by the online name Turtle Boy. He claims to be an investigative reporter, and he claims that he ardently believes that Karen Read is not guilty. And he is in the area and has created a whole group of people who go out on the corner and protest saying that Karen Read is not guilty. He has been accused of attempting to tamper with witnesses for confronting the witnesses against Karen Read, specifically the McCabe's and the Alberts, who are cop friends of John O'Keefe's. I don't know what happened to John O'Keefe, but I do know that the state didn't prove their case. So she's going to be tried again. I'm going to continue to talk about the legal issues in the case and whether or not I think the Commonwealth of Massachusetts has some serious problems, whether it's Sandra Birchmore or whether it's Penny McGee, or whether it is any of a number of other cases that Michael Proctor and his cronies have investigated, or whether it's Karen Read. And if that makes me woke, then so be it. I'm going to continue to talk about the legal and the constitutional issues in Karen Read's case. I don't want anything to do with Aidan Kearney and with all of those other peripheral stuff that's going on. He's been charged with witness tampering, and there's all this other stuff going on I don't care about. And if you guys want to hear about that stuff, there are a lot of creators out there who cover it. I'm just not interested in it. It's not my focus. So if saying that I don't believe that the Commonwealth proved their case makes me woke, then woke I am. So before we dive deep into Karen Read, I did want to talk a little bit about what we talked about last time and about where the channel goes from here. So I did want to also thank Casino Kelly and Rogue Koala, both, for really sweet comments. And I am going to read those because I just as sort of a sampling of some of the input that I got back. So Rogue Koala said, Lori, I've been with you from your first show, and you know that I'm so appreciative of what you do and your approach. You may not be the biggest channel on YouTube, but you're one of the best. I love not being hounded to like and subscribe or join or buy merch, although I would gladly do that for you. You've grown a small but dedicated community that agrees to disagree, does not bully others in the chat. So many of the larger channels have a chat so large that you stand very little chance of getting a question answered, and the chat tends to be more of a click and bullying does ensue. I can only think of one time, which was back around the Bad Lori's trial, that someone was removed from chat by the mod. This is a huge credit to you and the community you've created. You keep doing you. We're here for you and love the format. Don't let the YouTube machine and algorithm make you feel that you're not doing a great thing. We love you. P.S. Dying for your next project details. So I want to say thanks for that, because I was beginning to feel like with so many other competitors who were doing things so much more elaborately, and live streaming trials, and being on once a day or multiple times a day, that that maybe I was maybe you were getting what you needed from them, and maybe you didn't need me. I was kind of superfluous. I've always had trouble with that word. But I appreciate the input, which was that, first of all, that folks love this community and feel safe to ask questions and feel safe to post comments. And I have to agree that I think this community is amazing. And, Jen does our moderating, and she does a great job. But I appreciate the fact that she doesn't have a lot to do, because our community is respectful and able to disagree without being disagreeable. And I appreciate how much you all take the time to join me every week, and take the time to be thoughtful about how you interact with everybody else in the community. So I really do appreciate that. The other one from Casino Kelly says, I genuinely enjoy your lives and have been watching since your very first episode. I would like to see deep dives into one case at a time, though I also like these wrap-ups. I think also hearing your personal thoughts and opinions, in addition to the education you give on the law, is appealing. I've learned so much from you and really enjoy hearing your opinions and experiences as a defense attorney. Prior to watching you and Bob Motta, I never looked at things from a defense side, and hate to admit that I was one of those people who just took prosecutors at their word and assumed they were right. Now I feel ashamed of that and totally see that we need an overhaul of our justice system. You were instrumental in my seeing the truth in what's happening in our system. I think we need people like you. I want to say thanks so much for that, because it sort of led me to give a little bit of thought to doing a little more of that. And one of the things that has been troubling me, I don't think any of you will be surprised to hear that I'm not a huge supporter of our current administration. I don't think that comes as a surprise to any of you. I have done my best to keep politics out of this, because there are a lot of other channels that do politics much better and much more in depth than I ever could. But I do think, and I'm gonna let you know now, I do think that you should expect to hear a little bit more about the intersection of the Constitution and criminal justice, and what our current administration may be doing or attempting to do there. So just to give you all a little bit of a heads up that you may be seeing more content that has to do with the impact and the constitutionality or lack thereof of some of the actions the administration is doing as it relates to criminal justice. Now, I am not going to weigh in when it comes to a lot of the other political things that are going on, but I have been giving a lot of thought to that, how it impacts our criminal justice system as we go forward. So I think you may hear more of that. I did take to heart your thoughts about a deep dive into a particular case, and I think you'll be hearing more of that as well. I'm not ready yet to tell you about my new project, but you might hear something in the coming weeks. And once that has solidified, I think you'll hear more on our YouTube channel about my research and about that project. So, lastly tonight, I wanted to talk about these motions in the Karen Read case. As I said, Melanie Little covered them pretty much wall to wall, went through the motions line by line. So I don't do that. I don't want to take up your time doing that. That information's out there. But I do want to talk a little bit about some of the motions. The defense team just added a new member. His name is Mark Betterow, and he is a New York attorney. And I'm sure that you have seen him on several other true crime channels. He currently represents Aidan Carney. So there is sort of a crossover there, and I'm not sure whether there's a conflict there or not, but we'll see. But he has joined the team. There were a flurry of motions back and forth that have hit the docket. Now, the reason for this is because the judge initially had set aside the 18th and 19th, I believe, of February, so that's next week, for continuing motions. And she set those days aside to hear motions from both sides. And it's what they call an omnibus hearing. It means all motions, it's not set for a specific motion. It's just held open to have hearings on whatever motions are out there to be heard. So that's why both sides have suddenly just bombarded with new motions. One of the motions was to ask the judge to reconsider an earlier order about reciprocal discovery. Now, we've talked at length about discovery. Discovery means, and in criminal cases, there's a very seminal case called Brady versus Maryland from the US Supreme Court that ruled that prosecutors have to produce all information, including, and most importantly, exculpatory information to the defense. And so the prosecutor has an ongoing and automatic obligation to provide any and all information regarding the case, any and all evidence, or information that might lead to evidence to the defense. And there are always arguments back and forth about whether or not the prosecution, in every case, not just Karen Read's, whether or not the prosecution is complying with their obligations, whether or not they're withholding, whether or not they're slow walking. I mean, that is always an issue in cases. However, in Massachusetts, what the law says is that the law also says that there is a reciprocal obligation from the defense to turn over any information about any evidence that they intend to produce, to introduce at trial as well. So evidence, witnesses that they intend to call, and evidence they intend to put on. But Massachusetts law says that that does not necessarily include impeachment information. Okay. So in Karen Read's her first trial, the prosecution asked the court to order all discovery had to be reciprocal, including impeachment information. And the defense complied. And in doing so, they tipped their hand as to ways of impeaching the state's witnesses. For example, the state was able to prepare Jennifer McCabe for questions that were going to come up that the defense was going to ask, having to do with some text messages she sent and some conflicting testimony that she gave to the grand jury, and to specifically, I think, the federal grand jury. So they are asking now to be relieved of having to continue to turn over any of their impeachment information, because they believe that allowed the state to prepare their witnesses in ways that made them stretch the facts a little bit, or massaged their testimony so that there wasn't an impeachment possible, and so they're asking that the judge relieve them of the responsibility of having to provide reciprocal discovery in the form of impeachment discovery. I think that is likely to be granted, particularly since most of the impeachment information has already come out in the first trial. So they've asked her to reconsider that. There were also a couple of different discovery motions. And as I've said, discovery is a constant tug of war. And the sides are constantly pushing back and forth about, does the state have to turn this over? Did they? Are they? Did they slow walk it? Did they withhold it? And there have been a lot of discovery issues in this case. For example, the Sallyport video, the video of Karen Reed's car in the Canton Police Department Sallyport, didn't even get released to the defense until midway during the trial, the day before the prosecution offered it at trial. And that's really outrageous, really outrageous. So now the defense has filed requests for discovery. Specifically, they want the state to produce every one of those videos. So what was happening is that the state has produced these videos in little pieces. They have never produced the entire video of all the activity in the Sallyport that happened that night around Karen Reed's car. And they have never produced all of the video. Just recently, they produced a piece of video since the first trial that shows Trooper Brian Higgins. He's not a trooper. I think he's a ATF. I don't know. He's a federal officer, I think. But he has offices in the Canton Police Department. And he had said, when they try to get his phone, because he was friends with all those, he was part of the group that were at the bar the night that John O'Keefe died. I mean, he's in on it. He had said, I didn't talk to anybody. I wasn't at the Canton Police Department. I didn't. And when they tried to get his phone, he mysteriously had thrown away his SIM card, and so just recently, since the last trial, the state produced a video that shows Brian Higgins standing outside the Canton Police Department at 1:30 in the morning, talking to somebody on the phone, which he said he didn't do. So there's a lot of impeachment information in those videos. The other issues have to do with the metadata, because it's the metadata, the when was it created, how was it created, background deep data behind those videos that can show whether or not they were manipulated. Now, we know that when the state presented the Sallyport video that they produced to show that nobody tampered with the taillight on Karen Reed's vehicle, it was reversed. It was a mirror image. And so they produced it saying, making it seem like the driver's side was the passenger side and vice versa, so that when they showed people not around the taillight in question, it proved their point. But when you reverse the video, they actually were standing around behind Karen Reed's car and around that taillight in question. Now, the defense says that since the last trial, they have now received video. Alan Jackson argued at the last hearing that they have now received video that shows them backing the car into the Sally Port and that it is exculpatory. Now, that means that it shows that Karen Reed's not guilty. What exculpatory evidence must be that that taillight was intact. Now, she claims, and there's video to show, that when she backed out of her driveway to go look for John the next morning, she backed into his Traverse, I think is the name of the vehicle. And she cracked her taillight, the taillight on her car, her Lexus SUV, by backing into his car. Now, the state contends that her taillight was shattered when she backed into John O'Keefe, and that they recovered all of these taillight fragments from outside the house where John O'Keefe's body was found. They were found in bits and pieces over time, and no one knows how they got there, where they were. In a lot of cases, they just picked them up and they didn't document where in the yard they found them. And so it's impossible to say at this point. But if Karen Reed's taillight was intact when they backed her vehicle into the Sally Port, then that's pretty clear evidence that that taillight wasn't shattered at the time that they took possession of the vehicle, because the law enforcement has had possession of that vehicle ever since, that the damage to that taillight must have happened afterwards. And that it must then follow that those taillight pieces were scattered afterwards, which leads to more questions about the involvement of all of the law enforcement that were involved. So they are seeking to get all of those videos. They want the chain of custody logs. They want to know where the videos came from, who took possession of them, who had them in their possession, where they were stored. And they want to know every finger that touched those videos. And that's what they're asking for. They're also asking for information about the case of Sandra Birchmore. Now, for those of you who may not remember, Sandra Birchmore was a young woman. She was an Explorer Scout in the neighboring community of Stoughton. Both Canton and Stoughton are Boston suburbs, basically. And so this Sandra Birchmore was an Explorer Scout in the Stoughton Police Department. She was groomed from the age of about 13, and was having a long-term affair with Matthew Farwell, who was an officer at the Stoughton Police Department. And he was married, and he and Sandra Birchmore had a relationship that started when she was 15. She was 23 and had continued this relationship with him. And she had recently discovered that she was pregnant. And she was telling him that she expected that he was going to be a part of this child's life, that he was going to go to medical appointments with her, that he was going to participate, and that she was, in fact, going to have that baby. And Not very long afterwards, she turned up dead. Initially, the medical examiner ruled it self-harm. The medical examiner later withdrew that, and under pressure from her family and other outside organizations, then took a second look at it. When the police investigated, they believed that the scene had been staged to make it look as if it were self-inflicted. Matthew Farwell is now in custody and awaiting, has been charged with her murder and is awaiting trial in the very early stages. But many, something like 10 or 11 of the people who were involved in Karen Read's, the law enforcement personnel who were involved in Karen Read's trial, are also involved in Sandra Birchmore's case. And so the defense is asking for all of the police reports having to do with Sandra Birchmore. And they're being told, they initially were given redacted reports. They asked for the unredacted reports, saying that there's similar misconduct on the part of police that bear on the credibility of the witnesses in Karen Read's case. Now, because the Stoughton Police Department was involved in the case, they asked the Canton Police Department to come in and do the investigation. That's why a lot of the Canton Police Department folks from the Canton Police Department are involved in that case and are accused of having committed misconduct around that case as well. Michael Proctor, who's a Massachusetts State Police officer, was the lead investigator on both cases, on both Read and Birchmore, as well as Brian Walsh. And in the Birchmore case, he was responsible for handling some of the evidence. So now Michael Proctor has been on unpaid leave for almost a year and is facing disciplinary action and an internal affairs investigation. The defense also wants access to the internal affairs investigation, and of course, they're pushing back. So the judge is going to have to make a decision on whether or not the defense can have the unredacted information, as well as the internal affairs investigation information. The defense also wants access to the Karen Read's Lexus, John O'Keefe's Traverse, and they want access to the driveway where John O'Keefe was, John O'Keefe's home, in order for their own expert to do some testing and some measurements and some scans. I think that's going to be a no-brainer. My understanding, what I heard on another creator's broadcast, was that John O'Keefe's mother is living in the home with the children. Now, you might remember John O'Keefe's sister and brother-in-law both died kind of close in time to one another, and he was the guardian for their minor children. I think they were like 11 and 12, 11 and 13 when John O'Keefe died. So it appears that John O'Keefe's family has stepped in, his mother has stepped in to care for those children. So they are going to have to, the court's going to have to sign an order that gives them the access both to the vehicles as well as to the property. Because they want to reconstruct the accident in the driveway where Karen Read backed into John O'Keefe's car. There is Ring doorbell footage, but it's dark and it's snowing and it's not great footage of exactly what happened. So they want to reconstruct that. The Commonwealth has filed a motion to exclude the two experts, Dr. Wolf and Dr. Rensselaer, who were hired by the FBI when the FBI got involved investigating law enforcement. They got involved investigating Michael Proctor and whether there was misconduct in law enforcement. In the process of that, they hired these two accident reconstruction experts, both of them PhDs, one in biomechanical engineering, the other in engineering, that accident reconstruction type engineering. They were affectionately dubbed the Crash Daddies. And so I wanted to talk a little bit about sort of the legal ins and outs of how this works. If the federal government if the federal government comes alongside a local agency to help an investigation, as they did in the Lori Vallow case, where the FBI came alongside and they offered up their assistance doing interviews, they offered up their assistance using the FBI's labs for both tool marks and as well as forensic autopsy, forensic pathology, all of those kinds of specialties. So in that case, the federal government has an obligation to turn over what they come up with, whether it's cell phone data or anything, because they're actually assisting in a local investigation. They don't have any autonomy in the way that the case is investigated. However, in the Reed case, the FBI came in to investigate the investigators. The FBI came in to investigate the way that law enforcement had conducted this investigation. And that there was a federal grand jury that was convened, and that was a separate investigation. Now, they bled over into one another. They overlapped, but it actually is a separate investigation. So then we get into what's called TOUHY, TOUHY. And what that is a case that sort of outlines and rules that outline when the federal government has autonomy and when the state does. And when the federal government can, or the states can force the federal government to do something, which is basically they can't. So there is a process where the state then requests from the FBI, I would like to have these reports or this information. And then the federal government gets to decide what they release and what they don't. So Jen's just put up a TOUHY request is a formal request for government information to be used in a legal case when the government is not a party. Okay. So, right. But the government, it is easier to get information from the federal government when they are assisting a state investigation. When it's a separate investigation, as it was in this case, then the federal government has the right to say, "Nah, we're not giving you that." So they have been a little bit stingy about the information that they have released that was the basis of the Crash Daddies' findings. Okay. So they released the exact same information both to the state and the defense. That's what they got. Now the state is saying, we didn't get all of the information. We didn't get all of the the facts that they based their findings on. The feds didn't give them everything. And now they're saying they want to exclude the crash daddies from testifying because they didn't have all of the underlying data that they use to reach their conclusions. However, it is not within the defense's ability to get that any more than it is the state. And they're really grasping at straws to try and keep these two agents out. These two, they're not agents. They work for a private company that was hired by the FBI. They're really grasping at straws to keep these guys out because their testimony was so damning. And they were very clear that there is absolutely no way that Karen Read backed into John O'Keefe. And that the injuries that were caused were the result of him being hit by a car. So those are a couple of the really big motions that the judge is going to need to rule on. I don't think she's going to keep the crash daddies out, but I could be wrong because Judge Canoni kind of goes her own way. Although I will say that seeing her try the Peggy McGee case and seeing her preside over that and actually be the finder of fact gave me some hope that she is going to follow the law and that she is going to be fair. So I've had some real questions about her bias in this case, but I think a lot of people have had some real questions about her bias in the Read case, but we'll see. The final motion was a motion to exclude the testimony of a Commonwealth expert on dog bites. This guy is James W. Crosby, and I think he goes. If you want some really entertaining reading, read the affidavit from Dr. Russell. Dr. Russell was the medical doctor whose qualifications were challenged and who spent 2 days on the stand defending her qualifications before she was found to be an expert on dog bites. And this guy is nowhere near as qualified as she is, and in fact is not even a medical doctor. So he's an animal behavioralist, not even a vet. So I doubt he comes in. I think the defense will win on him. So, but it is entertaining. If you want a little bit of a snicker, you can read Dr. Russell's affidavit because it's pretty clear that she took umbrage with the state and the way that they treated her and how eminently qualified she is as compared to this guy. So. And that kind of wraps up the wrap up. And so I'm ready to take some questions if you guys have questions for me. While Jen's doing that, once again, I want to thank everybody for your really kind comments from last week, both in the chat and in our comments on YouTube. And thank you for your support. And it meant a lot to me to know that in spite of the fact that we have a lot of folks with a lot bigger productions and different production qualities, that you still find value here, and I appreciate that. So I'm going to keep doing it. We'll see once the new project kicks off how things change. But I appreciate, as always, all of you being here. And I appreciate all those folks that catch us on the replay. I did hear from Trisha the trucker. She said her schedule's changed, so she's not able to catch lives, but that she is A-okay, which was wonderful to hear. So hi, Trisha. Keep us in the loop and let us know what you're up to, because we worry about you being out on the road. So eat the food, Tina. Eat the food, Tina. If you could interview Lori Vallow, what would you ask her? Boy. I don't know that I would ask her questions. I think I would ask her to tell her story, and I would want to hear what she has to say. Now, do I believe what she says? I don't think so. I don't find what she said to Colby to be at all persuasive. But I believe she may believe it. But I don't know if I would have any specific question for her other than I would be really interested in just asking her to tell her story and listening, because I think that's when you get the most out of people like Lori. When you start asking questions, then they start second guessing, why are you asking? And, if you're just there and you're sort of a nodding, interested ear, I think folks like that talk a lot more. So I don't know. I mean, I'd be interested to know how she feels about Chad. I think all outward indication is she's still 100% with him. She's still wearing a hair tie around her finger as a wedding band. So it appears that she is still all in. I'd be interested to know whether or not they're communicating and whether they're able to communicate, and whether it's just letters or whether they can have phone calls. So I guess those would be some of my questions. But I don't know. I don't know that you would ever get, I don't think you would ever get the truth out of Lori. I just don't think I don't think it's in her. So that's an interesting question, though. I hadn't thought about that because I didn't think there's ever going to be any chance of me being able to talk to her. Hi, will you be attending the Idaho 4 trial this summer? I don't think so. I think I have some other things on my plate this summer. If my new project comes together the way I am planning and hoping for, I could be doing some traveling for that, and it probably wouldn't be practical for me to be attending the trial in Boise. However, if my schedule allows, I might try and go for some of it for a day or two, or drop in just to sort of get a feel for what's going on, since it's not that far away. It's about a 4-hour drive for me. So I will say, I know that Andrea Burkhardt is going to be covering it, and I know that she will be there, and so and she's wonderful. So I think for cover to cover trial, she'd be the one to go to. But I may try to get there just to sort of figure out the vibe, if my schedule permits. So, and if y'all are interested in hearing my impression, it is going to be held in the same courthouse and probably the same courtroom as Lori Vallow and Chad Daybell's trials are going to be held. So it'll be interesting to see how the atmosphere and the vibe might differ from Chad and Lori's trials. So good questions. Jane Blackbird. When reconstructing scenes, are they not held to the same time of day and weather conditions? Well, to the extent that they can. Time of day, yes. Weather conditions, I mean, I don't know that they're required to wait for a blizzard before they do that testing, but certainly they have to take into consideration the conditions at the time. So, they certainly have to take into consideration, was it icy, and when she put the brakes on, did she slide into John's car? Did she, those are certainly going to be factors and things that'll have to be factored in. So, but to the best of their ability, the best practice would be to try and duplicate the time of day and to take into consideration the weather conditions. But like I say, I don't know that they're going to be able to make sure that there's a blizzard going on, or that that there's snow on the ground before they do that testing. A lot of the testing that they're going to do is going to be measurements and taking laser scans and those sorts of things to be able to be very precise about the distances and those sorts of things. And then I think they're able to present to a jury the issue, and that's certainly a cross-examination question. You know, suddenly I have dogs up here who are having a free-for-all. So excuse me for just a minute. Out, come on, all of you, shoot. Those of you who know me know that the dog dad usually takes the dogs in another part of the house while I'm doing this. But for some reason, they just appeared in my office and decided that it was playtime and it was time to growl and bark at each other. So sorry about that. We're not that sophisticated in our production values. So, so they certainly in cross-examination, if they present that information, the state's going to come back and say, but in doctor or whoever's doing this reconstruction, you didn't do this when there was snow on the ground and it was icy and it was dark. And so those are all, appropriate cross-examination questions. Any updates about Lori's motion in Idaho with Judge Boyce Vallow case? Lori is acting as her own attorney, and she has motions that are pending in Arizona. The one that is pending at this point is a motion. She filed a motion to dismiss the case for lack of speedy trial, and the judge denied that one. But she has, my motions. Okay. To finish up, Lori has objected to the court, objected to court TV being the pool cameras in the courtroom. And the judge hasn't ruled on that one yet. I don't think he's going to give it much credence, but I mean, the worst that could happen is they could say, okay, court TV, you can't be the pool camera. It has to be Law and Crime or somebody else. But I don't think that's going to happen because they're just the pool camera. So as far as my motions go, I haven't refiled them. The last time I filed a FOIA request, I was told that all of those things were going to continue to be sealed until after Lori's appeals. I think that is BS. But I thought I would wait until after her trial, her Arizona trials, because then I think the court's got less to stand on in not releasing those and continuing to keep them sealed. So I haven't given up, but I am going to wait until after the Arizona trials are over, because the last thing the judge said was because she still had trials in other jurisdictions, he wanted to keep all the trial exhibits and all of the trial, all of the court documents sealed. So I still can't get to all of the motions and all of that stuff that they continue to keep sealed. So we'll see, but I'm not giving up. I'm going to get them. And who knows, it may be an update to the book when it comes out in paperback, which I don't know when that'll be, sometime next year, maybe. I always hear Fed time is easier than state. In what way and how big a difference is it? This is a good question. It really varies from facility to facility, and also varies depending upon what the defendant's charges are. So let's talk about it in in the context of Alec Murdaugh and the Murdaugh case. So he was facing both federal and state charges for primarily for the financial misconduct. The murder charges were state charges, but he had both federal and state charges for the financial crimes. And it's interesting that in our system, if you can be charged federally and at the state level for the same crime, and it's not double jeopardy. So he pleaded guilty to some of the federal crimes and at the state crimes as well. And he's serving his time in the federal prison right now. I think the federal, my understanding is, and I've never been in either one of them as an inmate, so the federal prison tends to be, particularly as it relates to white collar criminals, it's often called club fed or the federal tennis camp. So it is, especially among white collar criminals, it is easier time. They are allowed a lot more in the way of personal possessions. They're allowed a lot more access to electronics. They're allowed a wider variety of stuff that they can buy in the canteen. Definitely from a standard of living or quality of life aspect, I think that federal time is easier. When you get to people who have been convicted of violent crimes, I think that's less the case. I do believe that it is still more comfortable to be in federal prison than in state prison. And it also varies from state to state as to how the comfort of their state prisons. I would venture a guess that a South Carolina prison is going to be a very different environment from, say, Colorado. I think some of it depends on whether the state's sort of politically conservative or liberal. And I think that in states where there's more liberal leanings, sometimes there's also that more liberal leaning in the way that inmates are treated, and what sort of privileges they get, and what sort of privileges they can earn. So in state court, it is much more a case where an inmate earns their privileges. So good conduct or doing programs, or they can earn those privileges. They can earn having a TV in their cell. They can earn having a tablet, or those sorts of things. So it's much more behavioral driven than perhaps federal. So I would say in general, federal time is easier. The inmates have more freedoms and more comfort than in state prison, but it really varies from prison to prison. And, you still, even in federal prison, are going to have some influences of prison gangs, although not as pervasive as in states. In state prisons, you're certainly going to have the ethnic gangs. You're going to have Latinos. You're going to have African Americans. You're going to have white supremacists. You're going to have all of those groups. And, it's very difficult for inmates to stay safe if they don't affiliate in some way with some of those organizations within state prison. There's much less of that in federal prison. So I think that's another factor in people saying, oh, I'd much rather go to Club Fed. I'm going to tell you that there are no prisons that are pleasant. There are no prisons that are where life is easy. It's all really a matter of degree, because you're your freedom is still restricted and your liberty is still restricted no matter what prison you're in. Even state prisons that allow work camps for nonviolent offenders, those sorts of things, it's still prison, you know, and it's still the count, and jails no better. Jails are usually worse. In general, I think the food's better at Club Fed. I think they're, you know, perhaps the budgets are better for the way they take care of inmates. You may get quicker medical treatment, maybe, and maybe more appetizing food. So those are all good questions. Anybody got any more questions before we wrap up? Hi, Chelsea. I thought you were working on a project pertaining to grandparents. It's still in the works. It's still on the back burner, but I do have another project that's sort of come to the forefront. But that one, I'm still have that percolating. I'm still very interested in Donna Adelson's trial, and in Tiffany Adams' trial in Kansas. Still, those are still really on my radar, and that the whole issue of murder as a response to child custody disputes, that whole idea, and the idea of grandparents getting involved in that, and toxic grandparenthood, and grandmothers wanting to have control over grandchildren, certainly on my radar, and will be something I'm continuing to work on and to collect information about. I'm certainly going to be following both Adelson and Tiffany Adams very closely, and also Billy Wagner's trial. He's the last of the Piketon Massacre people who are going to be going to trial, and those three in particular are interesting to me because they involve murder because of grandmothers and child custody. So it's still there, and I am still working on it, but I do have this other project that I'm pretty excited about, and I'm going to know in the next week or two whether or not it's really going to gel, and then I will be working. I'm starting to work on a book proposal and a couple of sample chapters, and if that all comes together, then I'm hoping that I'm going to be able to announce something really soon. So, but it's sensitive enough that I'm not ready to let everybody know yet until I get that all sort of buttoned up. So, but thank you for asking, and I have a lot of stuff. Thank you, Rachel. Your toddler just informed you that she loves my earrings. So they're gold buttons. They were an anniversary gift from my husband quite a long time ago, and they are some of my favorites as well. They're just kind of a faceted gold button. So I'm glad your toddler likes them. I like them too. I've watched Arizona trials where jurors can ask questions. Is that at the judge's discretion? I believe it is at the judge's discretion. In most jurisdictions where juror questions are allowed, it is at the discretion of the judge whether questions can be asked. So I have not seen a state where the judge can't decide that. Now, in most states where it's allowed, most judges do allow questions to be asked by the jury. And the way that works is that after the state and the defense have both asked their questions of the witness, the judge would say to the jury and jurors, if you have questions, please write them down, pass them to the bailiff. The bailiff then gives them to the judge. The judge and both attorneys review those, and the judge makes a decision on whether or not that is an appropriate question to be asked. Sometimes it's something that doesn't fall within the rules of evidence. And I get that jurors get frustrated because the rules of evidence sometimes preclude them from getting information they really want. Things like 403B, evidence having to do with past crimes or having to do with past behaviors. So, I mean, one of the things that is going to come up in Lori Vallow's trial is whether or not The jury is going to know that she has previously been convicted of murder. I suspect the judge, I expect that the judge will not permit that to come in. So the jury will not be told that she is already serving 3 life sentences for murdering her children and her husband's first wife. They will have to make their decision based on that. And the reason is because it would be very prejudicial. It would be very hard for a jury to separate that out and to say, well, I need to figure out whether or not she committed this crime, whether she conspired to kill Charles Vallow. And I can't let my decision-making be colored by the fact that I know that she's already a convicted murderer in another state. So the judge is going to rule that that doesn't come in. But you know, the jurors could have those questions. And if they do, the judge is going to have to say, those are questions that are not appropriate information to be provided in this trial. So the judge has to decide whether or not the jurors' questions are appropriate and fall within the rules of evidence. They don't just get carte blanche. So I hope that they're going to be allowed to ask questions. Hi, Juliana. Are conjugal visits still a thing anywhere? I totally oppose that nonsense. Also, what do you know about anti-androgens administered to male prisoners? Are they mandated? I support that. Okay. Conjugal visits, unlikely. I don't know of any state that still allows conjugal visits. Y'all may know more than I do, but I haven't heard of any states that allow it. I think it was a thing for a while. And I get that it was sort of you could earn it. It was an incentive. You could earn private time with your loved ones. And, you know, it wasn't purely your romantic partner. Sometimes you were allowed an overnight visit with your wife and your children, or your husband and your children, or so. But I don't really know of any state that still does that. You can tell me if you know of a state that does, and the feds don't do it. So it's not a get me to club fed so that I can have conjugal visits. The issue of anti-androgens, and I'm not sure I'm pronouncing that right, and I'm not even sure that, but I know what you're saying. What you're saying is what would amount to hormone blockers or substances that help sort of lower sexual drive, or they also can serve to lower propensity for violence. I think there's some real constitutional questions to that. I don't know that it is administered across the board. I think there need to be some medical indications that it's appropriate. But I do think that there are some circumstances where those sorts of drugs are used in conjunction with other, say, antipsychotics and those sort of things, because you have a prisoner that is unruly and psychotic and violent. But I don't believe that there are, and I know that there have been constitutional challenges to that kind of slippery slope of medical interventions. I mean, where do we stop? Do we stop with that? Do we stop with mandatory sterilization, which happened in prisons and in mental hospitals? Do we stop with medical castration? I mean, there are a lot of it is a questionable practice, I think. Yes, I think that it may cause the population to be more compliant, but I don't know that it's helpful or that it's constitutional. So, the days of jails putting saltpeter in your food, yeah, no, that kind of went away with the 50s. I mean, mental hospitals, there was a time when mental hospitals lobotomized patients against their will. And that's certainly not a practice that is done these days. It's considered cruel and inhuman, and considered to be taking advantage of someone who is incapacitated. And, I mean, I think there is a real question about when the state takes custody of you and you are no longer have liberty, but you still have human rights, you still have your own human dignity. And when does the state get to take that away from you, whether it's forced sterilization, whether it's using inmates for medical experimentation, and for medication studies? I mean, I've just been recently reading a book about a case where there was they were using inmates to test drugs, and the inmates were volunteering for it, but it was a way to get better treatment. So I think those are thorny questions, ethical questions that we need to think about. We need to think about, yes, we believe in justice. We believe in holding people accountable. And we believe that in some instances that means for long periods of time or even permanently removing people from the general population and restricting their freedom. But where's the line? Where's the line where we have that person under our control, our meaning the government? Now that we have that person under our control, what are our responsibilities to that person as a human being? So those are all great questions, and questions we will continue to ask, because we are a chat that asks those and thinks about those kind of things. So with that, we've hit our 2-hour mark. I'm going to say thank you again so much for your continued support. If you are not already subscribed, please do that. Please hit the like button on your way out. It does help the algorithm, and I appreciate it. I will definitely get information out to you all about when and where I will be doing book events in Arizona and also in Boise. And I hope that I'll see as many of you there as can make it. So thank you again, Jen, for being the moderator with the most. And with that, we're going to say good night.